Having considered the evidence, there continues to be a need to protect the openness, landscape quality and functions of the river valleys within and immediately adjacent to the urban environment, and to ensure that the distinctive character of the Chelmsford City area is maintained. This was the conclusion reached by Inspector Yvonne Wright in her February 2020 report on the examination of the Chelmsford draft local plan in respect to Chelmsford's proposed green wedge policy. The inspector also recognised that the river valleys within and beyond the urban areas of Chelmsford are important multifunctional landscape, recreational and environmental features within the Chelmsford area. The green wedge is thus, like greenbelt, a functional designation, with associated policies intending to keep it free from most new development. But it is also, unlike greenbelt, a designation rooted in its identified landscape character and beauty. The green wedge is valued both for its own sake, for its assessed character and beauty, and also for the particular functions it performs. The purposes it furthers, as set out in Local Plan Strategic Policy S11, are preventing urban sprawl, preventing settlement coalescence, providing for wildlife, providing for flood storage capacity, providing for leisure and recreation, and providing for active travel by walking and cycling. These purposes are achieved by adopting a restrictive approach to new development in the green wedge. That is what the Associated Development Management Policy DM7 does, and why Policy S11 specifically points to it. The openness of the green wedge is thus central to its function and role. The appeal site is located in the River Chelmer East and Blackwater Navigation Green Wedge, Chelmer East for short, and at the western edge of the Lower Chelmer River Valley Landscape Character Area. The River Chelmer and its immediate floodplain is also designated as a conservation area. As Mrs. Hutchinson explained in her evidence in chief, and as you will no doubt observe during your site visit, this parcel of green wedge comprises the open floodplain of the River Chelmer, consisting predominantly of rough grazing, as well as smaller and more heavily vegetated fields at edges near the neighbouring urban areas. The appeal site is one such field. Within this context, it is obvious that the development of 55 dwellings, together with the removal of a considerable number of trees, will have the effect of introducing urbanising influences into an area designated precisely so as to protect it from such influences. Of course, the delivery of affordable housing will always be a clear benefit of any such scheme, attracting the substantial weight that both the appellant and Mrs. Hutchinson to the Council afforded, albeit using slightly different adjectives. The appeal proposal would make a relatively modest but nonetheless meaningful contribution to Chelmsford's affordable housing supply, and this is an important consideration. Set against this benefit, however, are significant harms to the green wedge and protected trees within it, harm to amenity of future occupiers through a scheme which falls short against several important design policy requirements, and residual harm to a number of heritage assets. It is the Council's case that even in a tilted balance scenario, these harms significantly and demonstrably outweigh the undoubted benefits of the scheme. Before turning to the harms in more detail, it is first necessary to consider the decision-making context in which the present appeal falls to be determined. Starting, of course, with the development plan, which, for the purposes of this appeal, comprises the Chelmsford City Council Local Plan 2013-2036, adopted in May of 2020, and the Essex Minerals Local Plan 2014, though there are, of course, no objections to the appeal on minerals grounds. There's no relevant neighbourhood plan in Chelmer Village. It is now common ground, notwithstanding paragraph 5.5 of the Statement of Common Ground, that the proposals conflict with that development plan, read as a whole. The reasons for refusal identify conflict with a number of strategic policies in the local plan, and in the interest of time I won't read them all out, but they're there in paragraph 8. Of relevance to the issues still in dispute between the appellant and the council, these principal policies provide as follows: that development which materially harms the role, function and intrinsic character and beauty of the green wedge will not be approved, that's S11B. That specific types of development may be permissible within the green wedge, provided they do not conflict with its purposes, DM7A. That planning permission will be granted where proposals do not result in unacceptable harm to the health of certain protected trees, including trees in a conservation area, DM17. That new development should reflect the 13 design principles set out in policy DM24 and be in accordance with the design standards in Appendix B, quote, unless it can be demonstrated that the particular site circumstances require a different design approach to allow for a lower provision. And finally, that new dwellings must achieve suitable privacy, private amenity space and open space, DM26A, and again for reference to compliance with Appendix B. Other relevant policies include policy DM13, which incorporated the requirements of the current paragraph 215 of the NPPF with regard to the impact of the development on heritage assets, and DM26B requiring sufficient on-site parking for new dwellings. An important point to note at this stage is that while these policies are rendered out of date by the absence of a 5-year housing land supply here, they're not aged. The plan dates from 2020. And perhaps more importantly, they're all agreed to be consistent with the NPPF. No case of inconsistency was advanced by any of the appellant's witnesses. Turning to that NPPF, the 2024 version is plainly relevant to the determination of the appeal, though of course it does not displace the statutory primacy of the development plan. It is agreed that the Council cannot demonstrate a 5-year housing land supply, and therefore that the tilted balance under NPPF paragraph 11D is engaged. Mrs. Hutchinson identifies a 6-part approach to the application of the tilted balance to the present appeal, and the Council invites you to adopt the same approach, Inspector. Mr. Dixon also agreed that it was appropriate. First, which policies are most important for determining the application? Second, are the most important policies out of date due to footnote 8 and the housing land supply position? Third, to what extent are out-of-date policies consistent with the NPPF? Fourth, are any NPPF policies protecting areas or assets of particular importance, as set out under footnote 7, engaged? Fifth, if so, does the application of these policies provide a strong reason for refusing development, or for refusing permission? And sixth, if not, would the adverse impacts of approving the development significantly and demonstrably outweigh the benefits when assessed against the policies of the framework taken as a whole and having particular regard to key policies? As for the first question, the most important policies for determining the application are of course those set out in the reasons for refusal and summarised above. There's no controversy about the list. The Council accepts that these policies are rendered out of date through the operation of footnote 8, and the primary effect of this is to engage the tilted balance. However, the operation of the tilted balance does not mean that the relevant development plan policy should be disregarded. They may still be taken into account, but the weight to be ascribed to them must be considered by you as the decision maker. One relevant factor will be whether the policies are in substance out of date, and that's taken from the case of the Gladman development, Uttlesford. Mrs. Hutchinson identifies that's really primarily about their consistency with the NPPF. Mr. Dixon accepted in cross-examination that this was a big part of the consideration of the weight to be given to out-of-date local plan policies. And this is also consistent with the approach in paragraph 232 of the framework regarding local plan policies adopted before the publication of the framework, which provides that existing policies should not be considered out of date simply because they were adopted or made prior to the publication of this framework. Due weight should be given to them according to their degree of consistency with this framework. The closer the policies in the plan to the policies in the framework, the greater the weight that may be given. Consistency with the NPPF obviously does not mean that there must be a direct analogue within the framework for every policy under consideration in the local plan. It is correct that there is no green wedge policy in the NPPF, as Mr. Young was pains to point out during re-examination of Mr. Dixon, but that's beside the point. The question for you is whether the policies most important for determining the application are consistent in a general sense with up-to-date national policy as set out in the NPPF, and Mr. Dixon agreed that they are. There is no evidence before you at all to suggest that they are not. The most important policies for determining the application were found by an inspector in 2020 to be consistent with the NPPF. While there have of course been changes to the framework since the local plan examination, none of these changes render the relevant local plan policies inconsistent with national policy. Mr. Dixon accepted as much in cross-examination. Indeed, the appellant has never alleged that any specific policy is inconsistent with the framework. Indeed, its case seems primarily to be that there's compliance with the local plan policies in any event. That is an important factor when considering what weight they should attract if, contrary to the appellant's case, they are breached by these proposals. Key policies S11 and DM7 are also retained in very similar form in the new Regulation 19 local plan, in which the boundaries of the Green Wedge are not proposed to be changed materially. The new local plan is, of course, not anticipated to be adopted before late 2026 or early 2027, undoubtedly tempering the weight which can be attributed to its policies, but it provides a further useful indicator that the Green Wedge policies are not in substance out of date. As such, Mrs Hutchinson's approach to reduce the weight to these policies on account of the absence of a 5-year housing land supply, but by one category only, given their residual consistency with the LPPF, is the right approach. She gives them substantial weight. Given the agreed importance of consistency and the agreement about it, there is no justification for reducing the weight as significantly as Mr Dixon does. Paragraph 11D1 of the NPPF provides that where the application of policies in the framework that protect assets of particular importance as set out in footnote 7 provides a strong reason for refusing development, permission should be refused. Whilst this engages policies protecting designated heritage assets, it's now agreed between the appellant and the council that the harm to heritage assets in the present case is at the lower end of the less than substantial harm spectrum, and does not in and of itself provide a strong reason for refusing development. The Green Wedge policy, despite its similarity to Greenbelt in certain respects, does not fall within footnote 7, and thus we turn to the final part of the 6-stage approach, the balancing exercise under paragraph 11D2. In its most recent revised form, this paragraph provides that permission should be granted unless any adverse impacts of doing so would significantly demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole, having particular regard to key policies for directing development to sustainable locations, making effective use of land, securing well-designed places, and providing affordable homes, individually or in combination. This is an evolution from previous iterations of the NPPF, which simply referred to the policies in the framework taken as a whole, with no specific policies highlighted for special consideration. Two of the paragraphs referred to in the new footnote 9, accompanying the revised text of this paragraph, are paragraphs 135 and 139, which set out national policy in respect of the design of new developments. This emphasises the particular importance of those issues in the tilted balance. Unlike Mr Dixon, we consider that the objective of achieving well-designed places is as much an absolute priority under the latest version of paragraph 11D as that of delivering affordable housing. It is also included as a point of emphasis in footnote 9. Otherwise, the fundamental balancing exercise remains the same. Permission should be refused where the harms significantly and demonstrably outweigh the benefits. Turning then to the breaches of the development plan policies which the Council has identified, and first to the Green Wedge, or main issue 1. The primary policies here are Strategic Policy S11, which sets out the overarching purposes of the Green Wedge, and Policy DM7, which provides for circumstances where development within the Green Wedge may be acceptable. The two policies self-evidently work in tandem and must be read together. The Council also contends that I've skipped a page. Pardon me. The Council also contends that the Chelmer East Green Wedge is a valued landscape within the meaning of NPPF paragraph 187A. While this policy was not addressed at all within the committee report, Mrs Hutchinson's evidence explains how a recent appeal decision in respect of the nearby Rosewell farm site drew attention to the characteristics of the Chelmer East Green Wedge landscape, which on her analysis bring it within the definition of a valued landscape. Whilst not at the very highest value, the landscape within which that site sits, a different part of the Green Wedge, was found by the inspector in the Rosewell Farm decision to have, quote, demonstrable attributes that elevate it above ordinary or everyday countryside, close quote. And this was sufficient even though the site itself was, quote, undistinguished in isolation. It is true that Inspector Wright, in examining the local plan, was not satisfied that the status of the Green Wedge as a valued landscape as a whole had been robustly demonstrated. She specifically noted that no valued landscape assessment using suitable landscape and visual impact criteria was before her. However, Mrs Hutchinson's evidence on this point is before you. In paragraphs 4.33 and 4.34 of her proof of evidence, to which in fact you were taken a number of times during her evidence and that of Mr. Williams, she has applied the Glivia Box 5.1 factors and those in the Landscape Institute's Technical Guidance Note 2 of 21, assessing landscape value outside national designations, to her observations on the value of the Chelmer East Green Wedge landscape in this location, following the approach taken in the Rotorn Farm decision. She notes that this part of the Green Wedge is representative of a distinctive river valley landscape with a degree of scenic quality. It has significant natural and cultural heritage value, being within the conservation area, and associated with the birth of industrialisation in Chelmsford, and has extensive public access, giving rise to significant recreational value. Its function is recognised in the Green Wedge designation. Overall, she has concluded that it has, quote, many of the attributes that contribute to making something a valued landscape. Mr. Williams alleged in rebuttal that Mrs. Hutchinson had made an important mistake in her valued landscape assessment by considering the landscape value of the Green Wedge first before the value of the site. But when pressed during cross-examination, he was unable to identify why this approach was impermissible or mistaken. The important mistake seemed simply to be that he himself might have carried out the assessment differently. In any event, it is clear from the text of the relevant local plan policies that the Green Wedge designation itself recognises an intrinsic character and beauty beyond that of ordinary countryside. Mr. Williams proved extremely resistant to accepting this conclusion during cross-examination, but we say that it is simply obvious. Policy S11B begins by stating, quote, the Green Wedge has an identified intrinsic character and beauty and is a multifaceted, distinctive landscape, and ends by providing, in the operative part of the policy, that development which materially harms the role, function, and intrinsic character and beauty of the Green Wedge will not be approved. The explanatory text to policy DM7, paragraph 8.48, begins, the Green Wedge is a local landscape designation. There is no proper consideration in the material provided by the appellant of this policy context and the enhanced value of countryside designated as Green Wedge. Indeed, in cross-examination, the position appeared to be implicitly that while the Green Wedge parcel within which the site sits might well be a valued landscape, the appeal site was not. What was clear is that Mr. Williams was not willing to see the appeal site as part of any wider landscape at all, and we say that that is surprising. In respect to the appeal site itself, the appellant has repeatedly characterised it as visually and functionally distinct from the wider Green Wedge landscape, with Mr. Williams variously stating that it is, quote, notably different from the wider open water meadow character of the Green Wedge located to its south, end quote, and highly enclosed with mature vegetation and no notable views out of the site to the Green Wedge. Perplexingly, the appellant has sought to present the boundary hedge at the southern edge of the appeal site and not the dual carriageway to the north as the true urban edge of this part of Chelmsford. This misses the point made by Mrs. Hutchinson in evidence and by us at the outset of these closing submissions, that the Green Wedge landscape is not homogeneous. It varies from open rough grazing in the river valley to smaller and more densely vegetated field patterns at the edges. Indeed, as Mr. Ford rightly pointed out in cross-examination of Mr. Williams, this heterogeneity is recognised in the explanatory text to policy S11B at paragraph 6.82, which describes the areas identified as Green Wedge as having distinctive landscape qualities and an important multifunctional role, and at 6.83, which describes the Green Wedge designation within Chelmsford's river valleys as a multifaceted green network. When the multifaceted nature of the landscape is appreciated, it is clear that the appeal site is entirely characteristic of this part of the Green Wedge, rather than separate from it. It is self-evidently part of it. In turn, it is part of a valued landscape. In the case of CEG promotions and the Secretary of State for Housing, Communities and Local Government, to which I'll refer a few times, and a copy has been circulated, Mr. Justice Ousley held that there was no general principle that planning judgments on whether a site was part of a valued landscape had to be reached by examining the demonstrable physical attributes of the development site alone. And he said it would be bizarre to adopt a wholly artificial approach to landscape evaluation, where in most cases a development site is but part of a wider landscape. That's paragraphs 58 to 9. The appellant has sought to present the physical characteristics of the appeal site itself as the beginning and the end of the question of whether it constitutes part of the valued landscape. It is not. Returning to the question of the application of the relevant policies, the appellant suggests that there is no conflict with policy S11 at all, and only a narrow technical conflict with policy DM7, because the proposed development does not fall within any of the categories of development permissible in the Green Wedge outlined in policy DM7A. Mr. Williams and Mr. Dixon take the view that the construction of 55 new dwellings and the removal of significant vegetative screening at the appeal site would cause, at most, only minor and thus not material harm in terms of introducing urban sprawl to this part of Chelmsford. We disagree. First, such an approach is an impermissible reading of the local plan. Policies S11 and DM7 work in tandem, as policy S11 sets out. It specifically says that DM7 defines what will and will not be acceptable in the Green Wedge. It tells us what will and will not conflict with the purposes of the designation. Further, and in any event, the proposals are in breach of policy S11 as well as DM7, and the breach is not technical. As Mrs. Hutchinson explained, the Chelmer Village Way currently marks the clearly defined and well-screened urban edge to the built-up area of Chelmsford, to the south of which the Green Wedge designation recognises the undeveloped nature of the countryside. The proposed development would be much more prominent in long-range views than the Chelmer Village retail park is at present, introducing a much starker and more visually dominant urban edge into the Green Wedge. As Ms. Stoughton explained on behalf of the appellant in the Heritage Roundtable session, the proposed planting scheme for the development is not intended to screen it from the public right-of-way network to the south of the site, but only to soften views of the scheme. Moreover, as Mrs. Hutchinson also highlighted, there remain open questions about the effectiveness of the proposed planting scheme, with significant planting proposed on top of the flood mitigation fund. The technical design of this fund has not yet been finalised, and it was clear from the roundtable session on trees that neither Mr. Spooner nor Mr. Williams had properly considered how the engineered aspect of the fund might affect its ability to support extensive planting. With respect, Mr. Williams' response that one sees trees growing alongside motorways all the time, and thus it could be assumed that they could be successfully established on the fund, did not inspire confidence. Overall, as Mrs. Hutchinson concluded, quote, the development will be considerably more intrusive than the current urban edge. That is self-evident in description of harm. To borrow her phrase during cross-examination, the development would protrude not like a finger but like a fist into the wider Green Wedge landscape, causing harm to which she affords substantial weight. It has been suggested by the appellant that Mrs. Hutchinson has intruded too far into landscape and visual matters in her evidence in respect to the impact of the proposal on the Green Wedge. This is patently not the case, and the unfortunate allegation that she has behaved professionally improperly in doing so is particularly inappropriate. Mrs. Hutchinson does not purport to be a landscape architect, but she does rely, as appropriate, upon the conclusions of the Green Wedges and Green Corridors Review Report, which formed part of the evidence base for the 2020 Local Plan Review, and on the Landscape Character Area Assessment for Landscape Character Area A7, when reaching an overall planning judgment on the impact of the appeal proposal on the Chelmer East Green Wedge. This is entirely appropriate and in keeping with case law. The Court of Appeal in the case of the Crown on the application of Liverpool Open and Green Spaces Community Interest Company and Liverpool City Council held at paragraph 45 that what is required when determining an application for development within a Green Wedge designation is, quote, a realistic assessment of the impact that a specific development on a specific site, or of a specific development on a specific site, I should say, and its surroundings, will have on the predominantly open character of the Green Wedge. It also endorsed the judgment of the court in Hook and the Secretary of State for Housing, Communities and Local Government, which concerned greenbelt policy but applied it to local Green Wedge policies in the Liverpool Open Spaces case. And in Hook, the court held that applying the policy imperative of preserving the openness of the greenbelt requires realism and common sense. Mrs. Hutchinson's observations on the deficiencies in the submitted LVIA, for example that it judges the visual effects of the scheme on the basis of a year 1 winter view, but only a summer view for year 15 plus, making it difficult to gauge the year-round effectiveness of the proposed screening, or perhaps I should say softening, would be evident to any informed reader of the document. She is a planning professional instructed by a public sector body to review the submitted LVIA, entirely in accordance with the Landscape Institute's own technical guidance note 1 of 20, reviewing landscape and visual impact assessments and landscape and visual appraisals. She has, quite correctly, engaged with the impact of the appeal proposal on some of the landscape features of the Chelmer East Green Wedge, which led to its designation in the first place. She has also applied the Glivia Box 5.1 and Landscape Institute TNG 2 of 21 factors to the question of whether the Chelmer East Green Wedge is a valued landscape, as we've already touched upon. Her observation that the LVIA's approach to landscape value seems to ignore the enhanced value that factors underpinning the Green Wedge designation lend is entirely appropriate. It does not even reference Landscape Institute TGN 2 of 20 in this context. We say she's correct, but even if you disagree with her conclusion as to whether this is a valued landscape, there is literally nothing improper about her evidence in this regard. Her work is carried out in order to reach a pragmatic and common sense planning judgment on the primary issue, namely whether building 55 homes and removing 32 trees and part of a hedgerow will have an adverse effect on the openness and character of this part of the Green Wedge. She has unsurprisingly concluded that it will, and we invite you to share that conclusion. Turning to heritage, main issue 2. The appeal site is located within the Chelmer and Blackwater Navigation Conservation Area and in the vicinity of 5 Grade 2 listed heritage assets. Barnes Farmhouse, i.e. the Fox and Raven, the barn at the east edge of Yard and Barnes Farmhouse, the Miller and Carter barn at Barnes Mill House and Barnes Mill Lock, including its gates. It is agreed between the appellant and the council that the application would cause less than substantial harm to a number of heritage assets by virtue of the impact on their settings. Barnes Mill and Barnes Mill Lock will not be affected by the appeal proposal. That the level of harm to the conservation area and to the Fox and Raven public house is a low level of less than substantial harm, and that the level of harm to the Miller and Carter barn is at the lowest level of less than substantial harm. The heritage harm would be outweighed by the public benefits of the scheme for the purposes of the heritage balancing exercise required by paragraph 212 of the LPPF, and the reason for refusal to therefore falls away. Of course, any residual heritage harm must still be carried forward into the overall planning balance, even where it is by itself outweighed by the public benefits of the scheme for the purposes of the heritage balance. Importantly, it must be given considerable importance and weight in that balance. Mrs. Hutchinson's assessment was that this harm should be afforded great weight in the planning balance, noting the high value of the assets concerned and the requirement to give considerable importance and weight to their preservation. You will have noted Mr. Dixon's concession that it was important not to double count the fact that only a small area of the conservation area would be affected. That underpinned Ms. Stoughton's assessment of the extent of harm and should not be leveraged again when considering weight. On the loss of trees, Policy DM17 seeks to prevent unacceptable harm to protected trees, including those within conservation areas. The latest information provided by the appellant indicates that the appeal scheme would require the removal of 32 individual trees and part of a 7-metre high hedgerow. All of the trees set to be removed are located within the Chelmer and Blackwater conservation area and therefore protected explicitly under DM17. Many of them are identified as trees of significance in the conservation area character appraisal. Trees contribute in a significant way to the character of the conservation area in this location, helping to soften the urban edges and protect the distinctive and tranquil character of the river valley. The removal of the existing protected trees would plainly have a detrimental impact on the character of the conservation area and the Green Wedge, opening up views of the appeal scheme itself and the Chelmer Village retail park beyond. It would also be a loss in its own right. The proposed mitigation for the loss of the existing trees and hedgerow is the planting of 198 new trees. We've already dealt with the Council's concerns over the likely effectiveness of the proposed planting and the interaction with the sign of the bund when dealing with the Green Wedge, and we don't repeat them here. But even on the appellant's own case, if all of the replacement planting is fully delivered and established by year 15, there will still be a short-term, i.e. up to 15 years, loss of a considerable number of conservation area trees. The Council considers this loss to be unacceptable and a breach of policy DM17A. Even if you're not with us on whether the harm to trees is unacceptable for the purposes of DM17, that harm does not disappear. As Mr. Dixon agreed, it must still be factored into the overall planning balance. rendering the debate about how exactly DM17 should be read somewhat moot. Where we would invite you to agree with Mrs. Hutchinson that it should attract great weight. On design, the appeal scheme falls short of the design standards in policies DM24 and DM26 and Appendix B to the local plan in a number of ways, in respect of back-to-back distances between plots, back-to-flank distances, and the provision of private outdoor amenity space and communal amenity space. It is agreed, albeit rather begrudgingly by the appellant, that outside city centre design standards apply to the proposed development, notwithstanding the fact that the legend to revision C of the privacy and proximity plan still cites inside city centre standards. Outside city centre standards require a minimum back-to-back distance of 25 metres between 2 to 3 storey buildings and minimum back-to-flank distances of 12.5 metres for a two-storey wall, with an additional 4 metres of separation required for each additional storey. Yet, it is apparent in the latest iteration of the privacy and proximity plan that plots 15 and 20 have back-to-back distance of just 9.09 metres, and plots 10 to 11 and 14 of 9.85 metres, less than 40% of the applicable standards. As Mrs. Hutchinson highlighted in her proof, albeit in relation to an earlier revision of that plan, the 4 first floor flats affected in these plots have their main bedrooms and living windows facing towards each other, with plots 10 to 11 and 14 also at an oblique angle, so that use of either balcony will lead to direct overlooking between the properties and a lack of privacy for future residents. The latest revision of the plan also indicates significant shortfalls against prior back-to-flank distances for plots 1, 4, 17, 20, 24, 26, 30, 31, 33, 35 and 36, with back-to-flank distance between plots 17 and 20 being just 3.72 metres, less than 30% of the required standard. The Council does not consider this to be an acceptable standard of amenity for future occupiers. Such are the potential overlooking issues that the privacy and proximity plan proposes to install opaque glazing on a number of windows in plots 4, 5 to 6, 14, 16 to 17, 20, 28, 30, 32, 33 and 35 to 6, some of which are the sole windows for a habitable room. In response to questioning from you, sir, during the design roundtable, Mr. Williams also conceded that bedroom 2 and bedroom, that should have a plot number, we'll clarify that for you, but the 2 more bedrooms in essence, and bedroom 3 and plot 36 being one of them, would be appropriate for some capacity, despite not being marked as such in the current revision of the privacy and proximity plan. The Council has significant concerns about the extent of the trade-offs between privacy and visibility, which will be required by the proposed scheme, which do not appear to have been fully thought through by the appellant. Both affect amenity. There are also deficits in the outdoor amenity space proposed on site. Using outside city centre standards, all of the proposed private gardens are at least slightly below local plan requirements, rather than simply the 4 which fall short of inside city centre standards. Mrs. Hutchinson accepted in response to your questioning that the percentage shortfall set out at paragraph 4.69 of her proof in respect of plots 27 and 34 were calculated incorrectly by reference to the standards for 3-bedroom properties, because in fact these properties have only 2 bedrooms. The correct percentages are 71% and 67% of the required standards respectively, still well below the minimum required. The overall point remains, obviously, that every single private garden is proposed to be below standard, and some quite considerably so. Mrs. Hutchinson also observed in her evidence during the design roundtable that the already constrained garden for plot 23, which measures 41.4 metres squared, interacts uneasily with the detailed boundary planting plan, which shows a hedge due to be planted on the northern site boundary in this location. Turning from private to communal garden space, Plan SP120A states that a purported 1,241 square metres of communal garden space will be delivered as part of the appeal scheme, but does not identify where the space will be. The appellant has proceeded on the assumption that the nearby Ruskin Road playground, accessed via an underpass beneath the A138, could substitute for communal open space, an assumption reflected in the committee report, which mistakenly applied the inside city centre standards in Appendix B. Applying the correct standards, which do not allow for nearby public open space to substitute for communal garden provision, the appeal scheme falls well short, and pointing to above minimum provision of public open space and or nearby parks misses the point. Communal gardens serve a wholly different function, as explained by the standards. Put simply, you cannot dry your washing in a nearby park. Mr. Williams relied heavily on what he characterised as exceptions to policies DM24 and DM26, and the standards in Appendix B to the local plan. It is true that DM24 and DM26 both allow for lower standards of provision where particular site circumstances justify a different design approach. And Mrs. Hutchinson accepted the need to approach the standards with a degree of flexibility. We shall turn in a moment to why there are no such particular site circumstances here. First, though, we must address another purported exception to policy identified by Mr. Williams, which properly construed is nothing of the sort. This is the footnote to criterion D in Table 9 of Appendix B to the local plan, concerning minimum distances between windows serving upper floor habitable rooms and side garden boundaries of adjacent properties. The text of that footnote reads, for corner turning plots, discretion will be needed as to the application of this standard. For example, the distance would be appropriate if the relationship is being imposed on an existing property. In new developments, the standard could be reduced if the plot serves a positive design function in the layout, as any new occupiers would be aware of the pre-existing relationship. Clear glazed upper floor windows serving habitable rooms should be avoided where they would directly face the privacy zone of the neighbouring property. The point being made here specifically relates to the interrelationship between upper floor windows and adjacent gardens. That is the criteria that it relates to. But the appellant has sought to use it to justify a lower standard of provision in respect of corner plots more generally, such as the intervisibility between bedroom windows on the first floor of plots 11 and 14, or the significant overlooking of habitable rooms in plot 15. We say the text cannot support that approach. Mr. Williams repeatedly suggested in his evidence to the inquiry that the various design issues identified by the council are justified because this is, quote, not a normal site, being constrained by its narrow shape. But of course every site is constrained by its size, and very few are exactly square. Design choices must be made to ensure that well-designed places are delivered within the constraints of every site. One such design choice might be to reduce the number of dwellings planned. In an intervention during the design roundtable, Mr. Young sought to contrast this with greenfield sites outside of city centres, or outside of cities rather, but of course this is a greenfield site, and it is not within the city centre. We accept that some flexibility can be applied in certain circumstances, but do not consider that this site in this location warrants the application of reduced standards to the extent that is proposed here. In fact, there appear to be no particular site circumstances which justify the number of breaches of standards here at all. Finally, it was striking that at several points during the design roundtable, Mr. Williams made comments to the effect that, 1, future occupiers could decide whether or not to move into a disproportionately affected property, for example a corner turning block, and 2, that landowners could decide to adjust elements of the properties, such as the opacity of the glazing in affected windows or the relationship between hedges and amenity space in private gardens, so as to maximise amenity. This neglects the crucial point, highlighted by Mrs. Hutchinson, that this would be an affordable housing development. Future residents are not likely to have much choice over the properties they move into, and tenancy agreements tend to prohibit tenants from making significant changes to the fabric of rented properties at least. The footnote to Table 9 in the local plan, too, operates from this assumption of choice on the part of future residents, which simply does not apply to a development of this type. Moreover, subject of course to your agreement with the currently proposed conditions, the installation and retention of mitigation measures designed to ensure privacy, such as opaque glazing and screening treatments, would be secured by condition, adding another restriction preventing future alterations, even if occupiers wanted them. For all of these reasons, the Council considers that the development would give rise to material harm to the immunity of future occupiers, to which Mrs. Hutchinson attached great weight. The scheme would breach the design standards set out under policies DM24 and DM26 and in Appendix B to the local plan, with no site-specific circumstances having been identified to justify the departure. Your attention was drawn several times to the length of the pre-application process and the number of iterations through which the design of the scheme passed. But the number of design iterations is irrelevant to the outcome of the scheme, which is still not well designed. Put simply, the proposed development is not well designed in a number of key respects. It does not comply with paragraph 135F of the NPPF, which states that planning decisions should ensure that developments create places with a high standard of amenity for existing and future users. Or paragraph 139, which provides that development that is not well designed should be refused, especially where it fails to reflect local design policies. Both of these policies are specifically cited in footnote 9, to which decision makers must now have specific regard when applying the tilted balance. National policy is clear that the application of the tilted balance does not provide carte blanche for the delivery of poorly designed places. That is what this would be. Concluding on harms, Mrs. Hutchinson has identified a range of harms arising from the appeal proposal, which fall to be weighed in the planning balance both as harms in their own right and because they give rise to conflicts with the relevant development plan policies. Put simply, the appeal scheme would intrude materially and unacceptably into the Green Wedge, lead to the unjustified loss of protected trees within the conservation area, and be poorly designed in a number of key respects, such as to give rise to reduced amenity for the proposed future occupants. We invite you to agree with Mrs. Hutchinson that the policies cited in the reasons for refusal are consistent with the NPPF and thus not in substance out of date. Conflicts with these policies should therefore be given their proper weight in the planning balance, even in a tilted balance scenario. Cumulatively, Mrs. Hutchinson gave substantial weight to the conflicts she identified with the relevant development plan policies, acknowledging that they could not attract full weight due to the housing and land supply position. We invite you to do the same. It was suggested by Mr. Young in cross-examination that this would be impermissible double counting to give weight to breaches of development plan policies concerning the Green Wedge, separately from the weight given to harm to the Green Wedge in its own right. Case law demonstrates that this is not correct. In CEG promotions, again, Mr. Justice Beasley held that it was appropriate for an inspector to have considered harm to a valued landscape under then paragraph 109 of the NPPF, separately from harm under landscape policies in the local plan. In Gladman developments in the High Court, endorsed by the Court of Appeal at paragraph 30, Mr. Justice Holgate, as he then was, held that it was permissible to assess the same factors against two different criteria or tests when applying the tilted balance, first under paragraph 11D2 and second against the statutory development plan in accordance with section 38.6 of the Planning and Compulsory Purchase Act. And in Brown and Borough Ealing, the Court of Appeal held at paragraph 31 that in principle it's possible for a particular factor to be relevant and to carry appropriate weight in the consideration of more than one planning issue. Now, none of these are direct analogues for the situation here, but taken together, it is clear that material harm out in the world, such as harm to a valued landscape and or landscape designated as Green Wedge, is not the same as harm to the plan-led system, which arises out of conflicts with development plan policies, even when those policies deal with the same subject matter. The same factor, harm to the openness and character of the Green Wedge, falls to be assessed in two different contexts, and both may properly be accorded weight in the planning balance. Equally, so long as the dual nature of that harm is acknowledged, i.e. both out in the world and amounting to breach of policy, they do not need to be treated separately. It's a question of approach. The planning balance. It is accepted, as I feel like I've said quite a few times at this point, that the tilted balance applies under NPPF paragraph 11D2. It is for the Council to satisfy you that the benefits of the scheme are significantly and demonstrably outweighed by the harms. We leave to one side here the hypothetical to which Mr. Dixon was led in examination chief, when he speculated that if footnote 7 policies on designated heritage assets were to provide a strong reason for refusal, because the heritage harms outweigh the public benefits of the scheme, such that the heritage balance was failed, that somehow the benefits of the proposed developments would still impossibly outweigh the harms on a flat balance. Given the position of the Rule 6 party on heritage, they may wish to make more of that point, but we leave it to one side. Turning to the benefits, Mrs. Hutchinson gave substantial weight, her top order of weight, to the delivery of affordable housing, fully recognising the national and local need to deliver more affordable homes. She gave further significant weight to the delivery of homes in general, in the context of the 5-year housing land supply shortfall in Chelmsford. There was nothing between her and Mr. Dixon in this regard. The transfer of land into public ownership to promote greater public access to the Green Wedge is also a benefit of the appeal scheme, albeit the weight which can properly be attributed to it is tempered by the fact that the land to be transferred is already crossed by a number of public rights of way, and so there's already significant public access. Mrs. Hutchinson gave it moderate weight. She also gave moderate weight to the provision of biodiversity net gain in excess of the now mandatory 10%, which is agreed not to apply to this appeal, and to the economic benefits of the construction of the scheme, including jobs creation. The Council fails to see how any of the other social or environmental benefits can properly be claimed without double counting, given that the proposed planting in open space to be delivered as part of the scheme will serve as mitigation for its harms necessary in order to satisfy the requirements of policy. They are not properly construed planning benefits of the scheme. Set against these undoubted benefits are harms which we have identified to the green wedge, designated heritage assets, conservation area trees, the amenity of future occupiers, many of whom may have limited choice over the homes they end up in, and to the development plan read as a whole. This is really where the main difference lies, as between the appellant and the council. Mr. Dixon's analysis grossly underestimates the harm in each respect, sometimes in reliance on the assessment of others and sometimes not. It is the council's contention that these harms, properly described and understood, significantly and demonstrably outweigh the benefits of the proposed development, and we invite you accordingly to dismiss the appeal.